you will be informed of which day you will have your test. Second point, the test is on paper. So no need, you don't have to bring your computer. I will provide for you the paper. You will need a pen. Okay? Okay, so now I will share the screen and we will start we will go back to our topic of last time. So we were talking about the state as an international person, as a subject of international law. And we came to the point where we discussed the issue of recognition, whether recognition is declaratory or constitutive. Now, first of all, we have seen that recognition is politically motivated. So the states decide to recognize, please, the recreation is finished. If you have something to say, you say to the whole class, not to your neighbor. Okay, we have seen that each state, when it decides whether to recognize or not a new state, is politically motivated. This decision is politically motivated because the new state will decide on the basis of whether it considers the new state as effectively a new state, whether it considers that the new state possesses the characters of a new state on one side, but on the other side, it will decide on the basis of whether it likes or not state, a new government, whether it considers that it can have it can establish stable relations with this new state or not, etc. Now, there are two theories. According to one theory, the recognition is purely declaratory in the sense that the state is merely declaring that the new state, in its view, possesses the characters of a state, but this does not have an effect of constituting, of establishing the legal personality of the new state. A declaration, a declaratory recognition will only imply that the state issuing such a declaration will not have the possibility of saying after a few months, no, this is not a state, because it would contradict its declaration. According to others, recognitions are constitutive, which would mean that, in fact, new states should be admitted to the international community. So recognition would be a sort of admission procedure on the basis of which the existing state decide whether or not to admit a new state in the international community. So this admission into the international community would be by means of co-opting by the existing states. The existing states would co-opt new states, new entities. However, this does not work. Why it does not work? Who has to recognize the new state? How many states shall recognize the new states to have a co-opting? Even the admission to the United Nations by the General Assembly, however relevant it is, it can take place with different majorities, but we cannot consider that the state which is not a member of the United Nations is not a state for the mere fact of not being a member of the United Nations. So it's certainly important, but so from the theoretical point of view, the constitutive theory of recognition is flawed. It does not work. And anyway, it does not correspond to practice. What we may say is that, however, recognition is important in practice. It is important to foster the consolidation of the effectiveness of a new state. Because if a new state is not recognized by anybody, this will mean that the new state will not be able to enter into relations with the other states. So clearly, a recognition by many states of a new state will enable this new state to, will help this new state to consolidate its effectiveness, and therefore to consolidate even its international personality. Anyway, it will enable this state to participate in an effective way to international relations. That is why, in particular, the admission to the United Nations by the General Assembly. Sorry, but sometimes I give a... Okay, can you hear me at home?
Yes.
Okay, thank you very much. Okay, I will try not to move anymore. So that is why the admission to the United Nations is important. Because clearly, an admission to the United Nations means that all the states who have voted in favor of the admission in the General Assembly of the United Nations, they are in fact recognizing the new state, because only states can be admitted to the United Nations. So the admission to the United Nations is a form of general recognition by the majority of the international community. And this may certainly help a new state, but please always take into account that if the new state is not able to stay on its own legs, it is not the admission to the United Nations which will solve this problem. take into account, we have some states which are quite weak. Take into account, for example, South Sudan, which is the most recent state being admitted to the United Nations. South Sudan was born, but was never completely effective, because it is a very poor state and in a status of practically a civil war. So it is not the admission to the United Nations which solves a problem of lack of effectiveness of a government, of a new entity. But when this effectiveness is there, the admission to the United Nations may help in allowing that state to fully enter into relations with the existing states, with the international community. So recognition, especially recognition by many states, especially recognition in the form of admission to the United Nations, will produce the consequence of consolidating a statehood which is already existing on the basis of effectiveness. On the other side, you have non-recognition. If the international community decides to withdraw or not to recognize a state, a new state, this can produce isolation of that state. And this is what happened, for example, to Southern Rhodesia, which was born in 1965. Southern Rhodesia was created in 1965 by a decision of the white minority, which declared independence from the United Kingdom. This was a decision in violation of a fundamental principle of international law, which is self-determination of peoples. The United Nations Security Council requested all states not to recognize Southern Rhodesia, and most states complied, in fact, not all of them. So Southern Rhodesia was isolated, but not completely. Anyway, can non-recognition prevent the formation of a new state, prevent the consolidation of a new state which was born in violation of fundamental principles of jus cogens? So can non-recognition more generally prevent the consolidation of an effectiveness which arose in violation of international law? I have some doubts. And we will come back on other situations. Anyway, do you have any questions on the issue of recognition? Or is it adequately clear? If it is not clear, you can ask. Okay, an example. This is an example of an exceptional situation which is not conforming to the normal to what normally happens. Is Palestine a state on the basis of what we considered as essential elements of a state? So I'm asking to you, is Palestine a state possessing population, territory, government, and a sovereign and independent government? Anybody wants to take the floor? I'm just asking whether Palestine possesses all the characters of statehood that we have considered as essential characters of statehood. No idea? What is possibly lacking in Palestine? Yes, please. Yes, you said claimed, territory claimed. Yes, well, it is not exactly a question of claiming, because yes, there are parts of territory claimed by both, such as Eastern Jerusalem, but that is a problem only related to some parts of the territory. But yes, I mean, you were right in identifying two problems, because yes, surely we have a Palestine population. Then there may be some problems in verifying whether in certain areas it is Palestine population or it is something else. But anyway, we have a Palestine population. We even have a Palestine territory, but because it is a territory which is to a certain extent defined, we have already considered the fact that territory does not need to have defined borders necessarily. So even if you don't know exactly what are the borders, there is a Palestine territory in two parts, divided in two parts, because we have on one side the West Bank and on the other side the Gaza Strip. We have a government, because we have the Palestine government, which is in fact to a certain extent exercising governmental powers over Palestine, over Palestinian population. But is this government sovereign and independent? No. This government is not sovereign and independent, because to be sovereign would mean to be the exclusive power over the Palestinian territory and population, which is not the case, because we know that Israel is exercising powers over this in relation to this territory and population. And it is not independent, because the Palestinian government is exercising some powers on the basis of, at least to a certain extent, concession by State of Israel. Certainly on the basis of agreements between the two parties, but in which, in fact, we may find a concession by the State of Israel, because the State of Israel continues to be considered by the prevailing opinion and also by the opinion of the International Court of Justice as a state which is occupying Palestine. So Palestine is still considered to be under Israeli military occupation. This is true for the West Bank, but where there is only a limited autonomy of the Palestinian government, always accepting the settlements, the Israeli settlements in this area. It is also true for Gaza Strip, because even if Israel is not present in the Gaza Strip, however, Israel is controlling the borders of the Gaza Strip, and Israel is guaranteeing the military control of these borders. So we cannot say that that Palestine is effectively a state, as we, in the sense that as we consider what the state has to be under international law. However, we know that Palestine is today recognized as a state by many states, and even by the General Assembly of the United Nations, which in 2012 there was an attempt to, because Palestine requested the admission to the United Nations, but the admission was not granted because of the opposition of the Security Council. The United States was opposing its veto in the Security Council to the admission of Palestine to the United Nations. Therefore, the admission was not possible, and therefore the General Assembly voted a resolution in 2012 in which it, on one side, it reaffirmed the right of the Palestinian people to self-determination and to independence, the right to independence in a state of Palestine, on the Palestinian territory occupied since 1967, which means it is still occupied. But on the other side, it decided to accord to Palestine the status of non-member observer state, therefore recognizing Palestine as an observer state, which is not member to the United Nations, so as a state. And on the other side, Palestine has been recognized by many states, and Palestine has been admitted to other international organizations, such as UNESCO or the International Criminal Court. So Palestine is acting as a state under many respects in the international community today. But this recognition, from which Palestine benefits, is due to political reasons. It is a recognition which has been used by the majority of the international community not as a way to certify that Palestine is already, under all respects, effectively a state, but as a way to promote the creation of a Palestine state. So recognition has been used in this case to promote the realization of statehood, of a statehood which is not yet effectively existing. Is that clear? Any question? Any doubt? Any different opinion? Yes, please. Can you speak a bit louder because you are at the end of the room and no, I heard the first, but just the last words, if you. Yes. I don't know if I got exactly what you wanted to say, but I don't think that what you said contradicts what we have said here. There are states that never recognize other states, so that decides for a long time not to recognize other states, but nonetheless, those states are existing, and they are even participating in international relations. For example, East Germany was not recognized for many years as a state by Western powers because of political reasons. They didn't want to accept the fact that the Soviet bloc controlled the eastern part of Germany. I'm talking of political situation because East Germany was a state. It had all the elements of a state. So the fact of being under influence of the Soviet Union didn't mean that it was not a state. So it was for political reasons that they didn't officially recognize Eastern Germany. But in fact, they even states not recognizing Eastern Germany would insert in some relations with East Germany. So the non-official recognition did not mean that East Germany did not exist as a state. So in fact, the situation for Rhodesia was even worse because due to the indication to the obligation imposed by the Security Council, practically all states, not all of them, but practically all states did not recognize Rhodesia. And this certainly entailed many difficulties for Rhodesia, but Rhodesia continued to exist. Certainly, we can say that after a few years, the situation was in fact reversed, and and the regime fell in Rhodesia, which also happened in East Germany, but after many more years. So we can say that in long terms, the isolation probably produced some results. But this, in my view, does not mean that non-recognition, in fact, necessarily prevents the consolidation of a reality which is not liked by the majority or even by the nearly the totality of the other states. Okay, anyway, we will continue to talk about issues which are similar to these now to a certain extent. So, sovereignty and jurisdiction. First of all, what did you, those of you who followed yesterday's conference, did you manage to follow? Because many arguments were not yet known to you. We have not yet touched those arguments, such as, of course, criminal jurisdiction, such as international criminal law, the International Criminal Court, immunity. Did you manage to follow the conference? I think it was very clear. And I think it was useful because it was anticipating some issues that we are going to touch and to see. Anyway, I suggest to all of you, for those who were not participating in the conference has been recorded and it is available for a few days on the team where it took place. So if I would recommend to all those who did not attend the conference to hear the recording of the conference. Because it touched important issues that we will take back in today, partly today, but especially in the coming future. Okay. We have considered the state, and we will now consider a fundamental attribute of the state, which is sovereignty. We have already mentioned the fact that sovereignty, intending by sovereignty the supremacy of the state over its territorial community, is the basis for the acquisition of statehood. But at the same time, sovereignty is the content of a fundamental principle of international law, which is sometimes identified as a fundamental right of the state. Sovereignty entails, in theory, at least when it was born, sovereignty was intended as the complete and absolute dominion of the state, the power of the state over its territory and over its people. In fact, the people were considered by absolute states in the 17th and 18th century as a property of the state. And everything which was in the territory of the state was considered by the absolute states as a property of the state. This, of course, is was valid at the beginning of the international community and is certainly no more valid today, because the sovereignty of the state is not subjected to any superior authority, if not the authority of international law. So every state, the sovereignty of every state is subjected to the limits posed by international law. And nowadays, international law poses evident and strong limits to the sovereignty of states. Now, we will talk about jurisdiction, which is the way in which the power of the state manifests itself. The jurisdiction is the concrete power that a state exercises over its territorial community. The state's jurisdiction is exclusive in the sense that no other state can exercise its jurisdiction within the state's territory. And this prohibition to exercise jurisdiction in the territory of other states is nowadays strengthened by the prohibition to use force in international relations. But this prohibition relates to the jurisdiction to enforce because, and this was touched in yesterday's conference, jurisdiction is divided in three different forms: the jurisdiction to prescribe, the jurisdiction to adjudicate, and the jurisdiction to enforce. The jurisdiction to which these three forms correspond, we may say, to the three different powers of the state, the three different functions of the state: the legislative, judicial, and executive functions of the state. So the jurisdiction to prescribe is the possibility, the power of the state to issue laws, to issue rules, binding rules. So the jurisdiction to prescribe consists in the power of legislation. The jurisdiction to adjudicate is very much linked to the jurisdiction to prescribe, because normally it depends on the jurisdiction to prescribe, but it consists of the power of the courts of the state, of the judges of the state, to consider cases and to issue judgments, binding judgments on those cases, on those disputes. And finally, the jurisdiction to enforce is the executive power of the state, the power of the state to coercively implement the rules, the laws, and the judgments issued by its courts. So it is the power of the state, which is, of course, which falls on the executive branch of government, on the administrative branch of government and the executive branch of government, and then especially it will be implemented by means of the police forces of the state. It is the power to use force within the state itself, within the territory of the state, to implement coercively the law. and the judgments. So the jurisdiction to enforce is the more tangible expression of the sovereignty of a state. And it is the jurisdiction to enforce which, by definition, can only be exercised by a state legally within its borders, within its territory. Although there are extensions of this territory, we will come back to that in a moment, because the state will also be able to exercise its jurisdiction to enforce on its private ships or its private aircraft when they are outside of the territory of any state, or its citizens when they are outside of the territory of any state. But a state cannot legally exercise its jurisdiction to enforce in the territory of another state. It can do so only with the agreement of the other state. So police agents, Italian police agents or Italian carabinieri cannot pursue an alleged criminal in the territory of Switzerland. They cannot try to capture an alleged criminal in the Swiss territory unless there is the consent of the Swiss state, of the Swiss Confederation, which sometimes happens. Sometimes the state will allow the agents of another state to enter its territory to exercise jurisdiction. While it is different for the jurisdiction to prescribe and the jurisdiction to adjudicate, because in principle it is possible for a state to exercise its jurisdiction to prescribe and its jurisdiction to adjudicate, even over persons and property outside its own territory, even when they are on the territory of other states. So this is called, of course, extraterritorial jurisdiction, because the state is legislating on issues that take place in the territory of other states. Or the state is issuing a judgment, the court of the state is issuing a judgment over, for example, a person which finds himself or herself in the territory of another state. Now, the limits within which the exercise of extraterritorial jurisdiction, I'm always referring only to jurisdiction to prescribe and to adjudicate. The limits within which this is possible under international law are disputed. Yesterday, the issue in question was only the exercise of criminal jurisdiction. So the power of the state to prosecute and punish crimes by means of its laws, first of all, and then of its judges, of its courts. Jurisdiction to prescribe and jurisdiction to adjudicate. But there are other possibilities there are laws of a state which do not concern the criminal field. For example, antitrust laws. Laws aiming to protect some specific conditions of the internal market of a state, but touching also the possible acts and behaviors of certain subjects even outside of the territory of the state. For example, the United States will exercise extraterritorially their antitrust laws or laws. Or another example is the United States sanctioning companies which trade with Iran in a violation of the sanctions decided by the United States against Iran. So even a foreign company which is trading with Iran will be sanctioned in as much as it violates the sanctions imposed by the United States. How will it be sanctioned? For example, by telling the foreign company, you cannot act in our territory. Of course, the United States is not able to reach a foreign company directly by the exercise of jurisdiction to enforce on the territory of another state, an Italian company, for example. But it can sanction it in as much as this company has activities in the United States. Or it can sanction it in other ways. But so the limits within which this is possible or not are disputed. Now even the European Union is acting in a similar way in many fields. Another possibility is the exercise of civil jurisdiction in an extraterritorial way. So the fact that the court will pronounce on a dispute between private persons or between private persons and company or between companies, in which only money is claimed. One party is claiming the payment of a sum of money by the other party. So this will be a civil dispute, not a criminal dispute. Also, this kind of jurisdiction to adjudicate in particular can be exercised extraterritorially. Now the point is, your textbook makes a unified discourse relating to extraterritorial jurisdiction and to the different kinds, the different heads, the different criteria, the different heads of jurisdiction that may be resorted to by states. I don't share the view in which your textbook does this, because in my view, there are different problems that arise in criminal jurisdiction with regard to civil jurisdiction and to other kinds of jurisdiction. So in my view, you cannot identify some unified criteria that may be used in all cases, in all these cases. The criteria that are identified in your textbook are especially related to criminal jurisdiction. Therefore, you find those criteria that were mentioned yesterday by Dr. Mariangela Lamanna. So the territorial head of jurisdiction, the jurisdiction based on nationality of the agent, the jurisdiction based on passive personality, so the nationality of the victim, and the jurisdiction based on the protection of fundamental state interests, and finally universal jurisdiction, which is when there are no links between the state and the dispute or the issue in question. Now, these different heads of jurisdiction are valid, in my view, in criminal jurisdiction, in relation to criminal jurisdiction, but not necessarily in relation to the other kinds of extraterritorial jurisdiction. So we will come back to an analysis, a short analysis of these criteria when we will talk about international criminal law. Do you have any question in relation to this? So don't be afraid. I mean, this part in relation to the different criteria will not be part of the intermediate exam. What is important now is that you understand the concept of jurisdiction and the three categories of jurisdiction: jurisdiction to prescribe, jurisdiction to adjudicate, jurisdiction to enforce. And the fact that the jurisdiction to enforce can, in principle, be exercised only within the state's territory, while the jurisdiction to prescribe and the jurisdiction to adjudicate may be, in principle, exercised within some limits, also extraterritorially. Okay? Do you have any question on these concepts? Yes, please. No. Extraterritorial jurisdiction to enforce is prohibited because it would violate the sovereignty of another state. So it is possible for states to exercise an extraterritorial jurisdiction to prescribe and an extraterritorial jurisdiction to adjudicate, but only within certain limits admitted by international law. The problem is identifying precisely those limits. So we will leave the analysis to international criminal law, because when we will talk about international criminal law, because in my view, those limits are sufficiently clear only in relation to the criminal jurisdiction field. Although certainly it is true that the state's courts in some cases have exercised, for example, universal jurisdiction as analyzed by your textbook, even in civil cases. Your textbook, for example, examines how the United States have changed their position in relation to the United States courts. The courts of the United States have changed their position in relation to the extraterritorial, in particular to the use of universal civil jurisdiction, because some time ago they had a very flexible and open attitude, but then they restricted the possibility of exercise of universal jurisdiction in the civil field, which is, however, to be kept separated from the criminal law field. Okay, so the concept is clear, and this is important for now, unless you have, of course, other questions. Now we come to the, well, a fact which is concerning the jurisdiction to enforce and the relation between jurisdiction to enforce and the jurisdiction to adjudicate in the criminal field is those cases, referring to those cases where a state captures a criminal abroad in violation of the sovereignty of another state. Now, the consequence of this violation should be that the state has no possibility to bring that person before its court in order to adjudicate and to decide on that crime. Although there are some instances of practice which would seem to testify the existence of a rule, male captus bene detentus, which would mean you have captured a person in a bad way, in a wrong way, in an illegal way. However, you can detain that person in a lawful way. So even if the person has been captured in an illegal way, you can detain that person in a legal way. And you can try and sentence that person to a prison term or even to the death penalty, as it happened in the Eichmann case. Because the Israeli illegally captured Eichmann, this Nazi official who was one of the most responsible for the Holocaust. Israeli agents in 1960 captured Mr. Eichmann illegally in the Argentinian territory and brought him to Israel, where he was tried and sentenced to death. So this was a very famous case. Israel, we may say, however, in this case that Israel presented its formal excuses to the Argentinian state, and the Argentinian state apparently accepted this, and therefore I don't think that the Eichmann case and even some other cases may testify of the effective existence of such a rule, male captus bene detentus. I think that the rule, the general rule shall be that if you capture a person illegally, you cannot try and punish that person. We had a recent example of this. What was this recent example? I cannot hear. The Russia case about with Navalny. No. I mean, there are other issues with the Navalny case because, but it is not a case of male captus benedictus because he was not captured abroad. He came back to Russia on his own initiative. Sorry? Yes, the Belarus journalist is a case because in that case there was a flight over the Belarus territory which was illegally obliged to land in Belarus, and consequently the Belarus authorities captured a Belarus journalist who was on board. This is a case of the capture of a person, leaving apart the issues whether this person may be totally innocent of what he is accused, but leaving aside this issue, he was captured illegally in violation of the jurisdiction of other states by forcing a foreign aircraft to land on the territory of the state. Yes, please. His trial should be illegal according to the general rule. In this case, we may say that probably Argentina was satisfied by the fact that of the excuses presented by Israel, and probably we may consider that the illegality of the capture was rendered legal by this acquiescence of Argentina in this case. But as a general rule, a person who has been captured illegally, in my view, shall not be tried and punished, cannot be tried and punished legally. Of the sovereignty of another state, yes. Now, let us go to territorial sovereignty. Yes, please, do you have a question? Can somebody repeat, because I couldn't hear. In my view, not. In my view, not. But of course, there are some people who claim that this rule exists. But in my view, this is not possible. Okay, any other question? So now let us come to territorial sovereignty and how territorial sovereignty may be acquired. Territorial sovereignty extends also not only over the territory of the state, but also over the territorial sea belonging to the state. We will touch this when dealing with the law of the sea. And also, it also extends to the airspace above the territory and territorial sea of the state. In those areas, the state is exercising its exclusive jurisdiction with some limits imposed by international law, as we will see. We don't yet know what are the limits of the airspace between airspace and outer space, but we will come back to this when talking about airspace and outer. How is acquisition, how is territory acquired? How is territorial sovereignty acquired? In principle, the acquisition of territorial sovereignty is based on the same principle as the acquisition of statehood. So it is based on effectiveness, on effective control, on the fact that the government is exercising effective control over a portion of land and the people and property situated in that portion of land. So once again, we find here an expression of the principle ex facto oritur ius. The law derives from the facts. The law is based on the facts. This is why in the past, for example, sovereignty could be established over a territory which did not belong to anybody, which was considered to be terra nullius, so a land belonging to nobody. And a state could extend its sovereignty by means of occupation, discovery and occupation. But discovery was probably not sufficient. You need to really occupy the land and exercise effectively your authority over that land. Now, of course, the problem was that the European states considered as terra nullius, as lands belonging to nobody, also lands which were inhabited and in which there were different forms of authority with respect to European states. And this is what led to colonization. But anyway, we are talking of a phenomenon which does not exist anymore because there are no more lands belonging to nobody. So it is no more possible to establish sovereignty over a new land by means of occupation. The question becomes more complex when a state wants to, or is pretending to establish its sovereignty over a territory previously belonging to another state. In the past, before First World War in particular, and to a certain extent until the Second World War, the state could, but especially till First World War, a state could conquer foreign territory by force, by means of a war of aggression. Other possible modes of acquisition of foreign territory were, and still are, prescription and cession. Cession is by treaty. Treaty, state A cedes a part of its own territory to state B by means of a treaty. Now, cession can take place even today. There were examples normally after many wars, after the Second World War, there were examples of cession of territories. For example, from Italy to France, some small portions of territory, or from even later on from Italy to Yugoslavia. Cession is possible, but of course it needs to take into account today the principle of self-determination. So cession shall be done in conformity with the principle of self-determination, which means that you cannot just sell a territory to another state, such as the United States wanted to acquire, to buy Greenland. As you know, recently President Trump wanted to buy Greenland from Denmark. This is not possible if not respecting the principle of self-determination. So you would have to ask the Greenlanders if they would like to be sold to the United States. I have some doubts. But anyway. Another possibility is prescription, which means that, for example, on a contested territory at the border between two states, a state which will continuously exercise its authority for a sufficient length of time would be able to acquire sovereignty over that territory, even if sovereignty is claimed also by its neighbor. However, if there is a legitimate title according to which that portion of land belongs to your neighbor, you can acquire territory by prescription only if there is a quiescence on the part of your neighbor. Because if there is a legitimate title, for example, a treaty, which attributes that territory to your neighbor, and even if you are exercising effective power, effective control over that land, but your neighbor continues to protest and does not recognize your exercise of sovereignty over that part of land, then prescription today is not possible. But inasmuch as there is a quiescence, which means that the other state accepts, it does not protest, it gives signs of accepting the situation for a long time, then prescription can also prevail over a treaty, over a legitimate title. Otherwise, it is the treaty which prevails. Okay? So today, a legitimate title would prevail, for example, if the dispute is brought before the International Court of Justice or another court, as it often happens. The court will recognize the legitimate title, in particular a treaty, unless there is prescription plus quiescence, which would in that case even prevail over previous treaty. Is that clear? And then we have the principle uti possidetis, the rule uti possidetis. As always, there is this use of Latin words, but the meaning of uti possidetis is that a new state, especially after decolonization, but we will see not only after decolonization, a new state shall follow the frontiers delimiting the old administrative entities and the previous sovereign. This principle was born in the practice of Latin American declarations of independence in the 19th century. But as the International Court of Justice clarified in the frontier dispute between Burkina Faso and Mali in 1986, this principle is now recognized as a general principle, applying everywhere. So, when different states are created where there was one single state before, one single colonial entity before, the state gaining independence will gain independence within the borders of the previous administrative entity within the colonial power. Let us see a visible example of what we are saying. This was Africa in 1920. You see in green all the French West Africa, in red all the English colonies in Africa, but the French territories and the English territories were divided in administrative entities. In French Africa, you had, of course, Algeria, Morocco, Tunisia, Mauritania, etc., Niger. In British Africa, you had Egypt, Anglo-Egyptian Sudan, Kenya, Uganda, Tanganyika, Northern Rhodesia, Southern Rhodesia, etc. Now, this is Africa today. More or less. I say more or less because if we had a look closer to Somalia, we would see that Somalia nowadays effectively controls only part of its territory, while there are other entities in Somalia controlled by other governments, however not recognized as states by the international community. But this is due to political reasons, not necessarily to a lack of effectiveness. What can you see in comparing the two maps? What do you see? You can see that the current states in Africa correspond more or less to the previous administrative entities within the in as much as we talk about the borders of these states to the previous administrative entities within the colonial entities existing before. I was showing the fact that the frontiers of Africa today, of the African states, between the African states today, correspond more or less to the internal frontiers of Africa in 1920. And this is due to the application of the rule uti possidetis, which is a rule, as I was saying, which was introduced, as the International Court of Justice says in the frontier dispute case, in order to prevent independence and stability of new states being endangered by fratricidal struggles provoked by the challenging of frontiers following the withdrawal of the administering power. However, I was saying the situation is more complex than that. The real situation is more complex than that because, in fact, many fratricidal struggles have not been avoided even within the boundaries of single African states. Especially in Africa, this happened because the administrative frontiers of colonies were often totally artificial and not corresponding to the realities on the ground, to the situation of the different peoples, the different ethnical groups on the ground. Anyway, the uti possidetis has been applied by international practice also to cases different from decolonization, in particular for the dissolution recently, in recent decades, for the dissolution of the former Yugoslavia. The EC Arbitration Commission on Yugoslavia, which was a commission on experts nominated by the European community, by the European Union, well, the European community at the time, in order to give an opinion on which of the former Yugoslavian state was qualified for admission to the international community, to be recognized by the European community member states, which was intended as a sort of admission to the, in fact, to the international community, but it was not the case. It was just that the European community wanted to have a voice in deciding which states to recognize. So what conditions did these states have to respect in order to be recognized and possibly to be admitted in the coming future to the European community itself? Anyway, according to the Arbitration Commission on Yugoslavia, except where otherwise agreed, the former boundaries had to become frontiers protected by international law. And this is what happened in the former Yugoslavia, because what mostly happened in the former Yugoslavia, at least apparently, because the frontiers of the old states, federated states within the Yugoslavian Federation, became the frontiers of the new states, Slovenia, Croatia, Serbia, Montenegro, later on, Bosnia, Herzegovina, and Macedonia. But now, of course, we also have Kosovo, which has emerged as a contested entity. We will see that in a moment. I still require a few minutes from you. And The situation of Bosnia-Herzegovina is extremely complicated because it is formally a state, but in fact it is a divided entity. Anyway, the borders between these major entities have remained in essence the borders existing before independence. Now, today, the taking of foreign territory, as I already mentioned before, could take place in violation of one or the other of two fundamental principles of international law: the prohibition of the use of force if a territory is captured by force, or the self-determination of peoples, according to which, as we will see, peoples subjected to colonial rule or to alien domination have a right to become independent and to decide anyway their political condition. So as a consequence, a state which would have acquired control over a territory in violation of one of these two prohibitions would be obliged to release such a territory, and the other states are obliged not to recognize the sovereignty of that state over that territory, and not to recognize the acts of government performed by that state over that territory, and not to assist that state to maintain that territory. And they shall cooperate among themselves to induce the state which has unlawfully acquired a territory to cease its unlawful acts and to release that territory. It is often the Security Council of the United Nations which reminds states of these obligations by means of binding resolutions, which happened in particular, for example, in 1990, when the Security Council reminded all states that they couldn't recognize the annexation of Kuwait proclaimed by Iraq after Iraq invaded and occupied Kuwait in 1990. Apart from these situations, if we talk about secession, so the creation of a new state in particular as a consequence of secession, but also the separation of a part of a state which accedes to another state. Secession is a fact. It is neither supported nor condemned by international law, unless, I repeat, it happens in violation, for example, of the self-determination of peoples. In 2010, the International Court of Justice was requested an advisory opinion about the independence declared by Kosovo, by the provisional institutions of self-government of Kosovo. The General Assembly of the United Nations requested the court whether this declaration of independence was in accordance with international law. The court restricted its answer just to the formal question whether the Declaration of Independence was in violation of international law, and it said no. It is not in violation of international law because international law does not prohibit a group of private people to declare independence of a territory. The court considered that it was a group of private people who met in Kosovo and declared independence because they didn't make so as the official parliament of Kosovo, but as the parliamentarian of Kosovo meeting in an informal way, we may say. But the court did not answer the question whether Kosovo was independent, or whether this secession was successful or not, because the court interpreted in a limited way the request posed by the General Assembly. So this advisory opinion is not very helpful because the court is only saying international law does not prevent a group of people from meeting in a room and declaring the independence of a territory. And a different issue is when an annexation takes place in violation of international law, such as I think and the prevailing opinion considers the case of Crimea. Of course, in this case, the Security Council could not recommend not recognition because Russia would have vetoed the resolution, has vetoed proposed resolution. But it was the General Assembly in this case to recommend states not to recognize the validity of the annexation by Russia of Crimea. Which took place as a consequence of a military invasion, although without practically any shot being fired. Now my final question is the acquisition of territory in violation of international law forever prevented? What do you think about it? And anyway, if you have questions on Kosovo or on Crimea, Kosovo is a disputed independence. Still today, it is a disputed independence, recognized by many states, not by others, and with a disputed effectiveness of the new state. But Kosovo is recognized by many states, and it is a member of a certain number of international organizations, not the United Nations, where it has not been admitted. While many states continue to protest on the acquisition of Crimea by Russia. Any question, or what is your opinion in relation to my question? Of course, there are different opinions and different ways of seeing how things have taken place. But this is the way that I exposed to you was in fact shared by the majority of the international community in relation to Crimea. I personally think that it is doubtful that a de facto situation may be forever prevented to acquire legal legitimacy. Anyway, we will come back to these questions at the beginning of our next class, and I will see you on Tuesday for the class, and then I will see you for the intermediate exam.